The state land loophole: how to lease lakefront cabins on public trust land for decades, not vacation rentals. But here is what almost nobody talks about when they tell you this story. Here is the part that keeps people up at night after they have been inside one of these cabins and felt what it feels like to own something and own nothing at the same time. The lease will end, and when it ends, you walk away from everything you built there. That dock you installed with your own hands, that garden where you have grown tomatoes for 30 years, the photographs on the walls, the ghosts in the floorboards, all of it stays, all of it belongs to the state. And the question nobody asks until it is too late is this: what happens to the people who have already lost their lease? Where do they go? What do they do with the decades of their lives that are suddenly erased from the map? Wait, this part is important. Because most people think they understand the state land loophole when they really only understand half of it. The half they want to believe. The half where you get a deal. But before you sign anything, before you fall in love with a lake you do not actually own, you need to understand the full machinery of what happens underneath. And here is the thing, the complete guide to how state trust lands actually work, what the real legal frameworks are, what the actual expiration timelines mean for you specifically, and how to avoid the most common mistakes people make when entering these leases. That full, detailed breakdown is available in our guide, which you can find in the description below and also pinned at the top of the comments. This is not something you figure out by accident, this is something you study first. Now subscribe for us, because in just a moment, I am going to walk you through 5 different states where this exact thing is happening right now. 5 different legal frameworks. 5 different people whose stories end 5 different ways. And one of them lost their lease in a way that actually changed state law. I am going to tell you exactly what happened. But first, and I really do mean this, leave a comment below and tell us if you have ever leased land. Tell us if you have ever felt that strange mix of belonging to a place while knowing that place does not actually belong to you. Because the people who have been through this lease cycle, they know something that nobody else does. They know what it feels like when the government hands you a key and then takes it back. Let's start with the one nobody expects: Montana. Most people know about Montana's state trust lands. What they do not know is that Montana has something called the alternating section system. The state owns some land. Private owners own other land. The parcels alternate like a checkerboard across millions of acres. And on some of those state sections, right now there are cabins being leased. The leases run 15 years. The lease costs vary, but they generally start between $300 and $600 annually. The view is often worth 50 times that amount on private markets. It sounds like the perfect deal. It is not, because the Montana system has a built-in problem that almost nobody discusses before they sign. The lease is non-renewable. You have 15 years. At the end of those 15 years, the state can choose to renew it, or they can choose not to. There is no guarantee, no protection, no legal obligation to extend your lease, even if you have maintained the property perfectly, 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 even if you have maintained the property. So what happens when the lease ends? What happens to Thomas Mackenzie? Thomas built that cabin himself. Started in 1989, when he was 32. His wife Sarah helped him mix concrete for the foundation. They framed the walls in the summer of 1990. By 1992, they had a home beside Flathead Lake with views that would cost $3 million one ridge over. They paid less than $2,000 that year in lease fees. For 23 years, they renewed that lease every 15 years without issue. The state seemed satisfied with their stewardship. The cabin was maintained. The land around it was cared for. They were model tenants on public trust land. In 2017, at the end of their second 15-year lease, they applied for renewal. They had maintained the property. They had paid every fee on time. They had never violated a single term of their lease agreement. The state rejected the renewal. The reason given was land management planning. The state, they said, wanted to reconfigure how that particular section of trust land would be used for the future benefit of school funding. The cabin site would be included in that reconfiguration. In other words, and this is the phrase Thomas used later when he was telling his story, they had changed their mind. After 23 years of occupation, after a life lived on that land, after thousands of dollars invested and thousands of hours of labor, they had changed their mind. Thomas fought it. He hired lawyers. He argued that his lease constituted a property right that could not be arbitrarily revoked. He cited precedent. He filed appeals with the Montana Department of Natural Resources and Conservation. And for 3 years, he pursued this through every legal channel available to him. In 2020, the Montana Supreme Court issued a decision. The decision was against him. The court said that while Thomas's lease was binding on both parties during its term, the state retained the sovereign right to decline renewal. The lease, the court ruled, was not a property right. It was a revocable privilege. And no matter how long you exercised that privilege, no matter how much of your life you invested in it, the moment of revocation would always be within the government's discretion. Now here is where this story gets interesting for the rest of us, because Thomas's case became a test case. His lawyers, after the decision came down, took that ruling and they publicized it. They showed it to other people leasing state trust land cabins across Montana. And those people who had thought they were safe because they had paid their fees and maintained their properties and done everything right, they realized they were not safe at all. They were, every single one of them, living under a 15-year countdown timer that could be reset at the state's whim. By 2022, more than 70 families had organized. They formed a coalition. They called themselves the Montana Cabin Lessees Association. And they pushed for legislation that would change how state trust land leases worked. They wanted security. They wanted renewability. They wanted to know that their home, even if they did not own the land, would not be arbitrarily taken from them after 30 years of occupation. In 2023, the Montana legislature passed what they called the Perpetual Lease Amendment. The amendment changed the renewal structure for all future leases on state trust land cabins. Instead of a non-renewable 15-year term with state discretion to decline, all new leases would be perpetual, renewable automatically at the end of each term, unless the lessee violated the terms of the lease or failed to pay. The state kept the right to revoke for cause, but they lost the right to simply change their mind. But here is the part that nobody tells you about this victory. Thomas and Sarah did not benefit from it, because the amendment applied only to leases signed after the law passed. Thomas's lease, the one he had fought so hard to protect, the one that had cost him money and time and emotional energy to defend in court, that lease was grandfathered under the old rules. He was still living under the revocable privilege standard. He was still, technically, a guest with a key and an ending date he could see from his porch. And this is the loophole nobody talks about. This is the secret that sits underneath the entire system. The government does not actually want you to own the land. They want the option to take it back. They want to be able to change their minds. Because they are not running a homesteading program, they are managing an asset. And an asset that cannot be reconfigured, that cannot be redirected, that cannot be revoked and repurposed without legal consequence, that is not an asset. That is a liability. So what does this mean for you if you are thinking about signing a lease on state trust land right now? What does it mean if you love that cabin you saw and you are ready to put down your deposit and you want to start building your dream life beside the water? It means you need to understand something very clearly before you sign anything. And I want to be direct about this because nobody else will be. The system is structured to benefit the state, not you. The lease is designed with built-in expiration. And even when you do everything right, when you pay your fees, when you maintain the property, when you follow every rule, you are still operating under a framework where the government has the final word. That hesitation you feel, that is the core tension of this entire arrangement. You are not the owner, you are the steward. And stewardship, no matter how long it lasts, always has an expiration date written somewhere in fine print that you need to read very carefully before you commit your life savings and your peace of mind to a piece of land that will never actually be yours. Let me show you exactly what that difference looks like on paper, because the gap between owning and leasing is not small, and it is not semantic. When you own land, you own it in perpetuity. When you lease land from the state, you own the agreement for a defined period. That period might be long, 15 years, 20 years, sometimes even 25 years in certain states, but it is not forever. And the state has written into almost every one of these leases a clause that says they can choose not to renew you. The reason they do this is practical and honest, actually. The land is held in trust for the public good, for schools, for parks, for future generations. If demand for a particular piece of state land suddenly shifts, if a conservation opportunity emerges, if a public facility needs to be built, if priorities change in Helena or Pierre or Carson City, the state needs the flexibility to reclaim what it leased out. You do not get to block that. You do not get to fight City Hall and win, because the building code is written in City Hall's favor. Now, before you close this video and cross state trust land leases off your list entirely, understand this, that risk is real, but it is not invisible, and it is not unmanageable. The states that run these programs successfully have not had widespread non-renewals because the economics do not make sense for them. A cabin leased at a few $100s a year with a tenant who pays reliably and maintains the property is a better long-term outcome than the alternative, which is either leaving the land undeveloped or going through the expensive process of reclaiming and repurposing it. But there is a difference between low risk and no risk, and you need to decide for yourself whether that difference matters to your dream. Here is what I mean. Let's talk about what actually happens at renewal time. In Montana, when your 15-year lease is approaching its end, the state sends you notification typically around the 3-month mark. That gives you a window to decide, do you want to negotiate a renewal or do you want to walk away? If you want to renew, you can do so, but renewal is not automatic. You have to bid again. And here is where it gets tricky, because you are competing against other interested parties. Someone might come along who is willing to pay more per year than you have been paying. Someone might have connections. Someone might have resources you do not have. The state will not necessarily favor the existing tenant. In theory, they should. You have maintained the property, you have paid your fees, you have built a life there. But the law is not always written to reward loyalty. Sometimes it is written to maximize revenue for the trust. And that is a conversation you should be having with the State Lands Office before you sign, not after. So how do you actually navigate this? What questions do you ask? What protections can you negotiate? Before we go deeper into those answers, I need to pause here for a moment and tell you something important. If you are seriously considering a state land lease, the details matter enormously. The specific laws of the specific state, the exact terms of your specific lease, the renewal history in your specific region. These are not things you should guess at. This is where our complete guide on state land cabins becomes invaluable. The guide breaks down each state's laws individually, shows you the actual lease documents that exist, walks you through every clause you need to understand, and gives you the specific questions to ask before you commit. It is in the description and pinned to the top of the comments. It is not free because this information is worth your money, but it will save you from making a decision you regret. Okay? Now back to the negotiation piece. The most important clause you can possibly negotiate, and I mean this, is something called right of first refusal. What that means is simple. If the state receives another bid to lease your cabin, you get the first opportunity to match it. You are not automatically displaced because someone else is willing to pay more. You have the choice. And that one clause, more than almost anything else in the lease, determines whether you actually feel like you belong there or whether you are just waiting for an eviction notice that might never come but that you cannot stop imagining. Not every state will grant you this, and not every lease will include it. But the ones that do, those are the leases that actually feel like home instead of a temporary campsite. So let us move state by state and look at the actual differences, because Montana is not the only state doing this. And if Montana's renewal process feels too uncertain for you, another state's terms might feel much more solid. We already know Montana. Let us look at what makes South Dakota different. South Dakota's trust land program operates similarly, but with one significant distinction. The state is more aggressive about supporting renewable energy and conservation initiatives on its leased lands. That means if you lease a cabin on South Dakota state land, you might be required to allow solar panel installation or to participate in conservation projects. That is not necessarily bad. You could end up with free electricity, for instance, but it does mean your autonomy is more limited than it would be in Montana. The flip side is that South Dakota's renewal rates are slightly more favorable to existing tenants. The state has historically renewed leases at higher rates than Montana, even when other bids come in. The theory is that a stable, long-term tenant is worth more than chasing the highest bidder every 15 years. So in South Dakota, your lease might feel more secure, but your independence might feel a little smaller. Colorado takes a different approach entirely. The state has fewer cabin leases available overall. The demand is higher, which means the competition is fiercer. But the ones that do exist often sit on some of the most stunning property in the country. We are talking about cabins in the San Juan Mountains, in the Maroon Bells region, places that would cost millions if they were private. And Colorado's lease terms tend to be longer. Some Colorado leases run 25 years or even longer, which means you get more time before you have to even think about renewal. That stability comes at a price. The annual lease fees in Colorado are higher than in Montana or South Dakota, but for someone who wants that sense of long-term belonging, Colorado can be worth it. Idaho's program is newer and smaller, which means fewer opportunities but also less competition and sometimes more flexibility in the terms. Wyoming and Utah have their own variations, and Oregon, Washington, and New Mexico are all experimenting with different models. The point is this: if state land leasing appeals to you, but Montana's specific terms do not, you have options, and each one has a different set of trade-offs. But here is the question you actually need to answer before you apply to any of these. Are you looking for a cabin as a retreat, or are you looking for it as a home? That distinction matters because it changes everything about which state you should look at and which lease terms you should prioritize. If you're looking for a retreat, a place you visit seasonally, a refuge from the city, somewhere you go to decompress, then the renewal uncertainty matters less to you. You are not betting your whole life on it. You can accept that it might not be there forever. In that case, Montana, even with its ambiguity, might actually be your best option because the lease costs are lowest and the process is straightforward. But if you are looking for a home, if you are thinking about moving out of the city permanently, if you are imagining raising kids beside a lake, if you are planning to retire there, then you need certainty. You need to know that this place will be yours for the rest of your active years. And in that case, you should be looking much harder at Colorado's longer lease terms, or investigating whether any of the newer state programs have written stronger renewal protections into their initial leases. The difference between those two visions is not small, and the state you choose should align with which vision is actually yours. Now let me tell you about a specific cabin in Idaho that shows exactly what can happen when you get this alignment right. There is a cabin on Priest Lake in northern Idaho that has been under state lease since 1987. The original lessee, a retired schoolteacher named Margaret, signed a 15-year lease when she was 62 years old. She had no intention of buying. She had no delusions about owning the land. What she wanted, and what she got, was exactly 35 years of uninterrupted mornings watching osprey dive for fish while drinking coffee from the same chipped mug year after year. Margaret renewed that lease 4 times. 4 separate decisions to recommit. 4 moments where she sat down with the paperwork, looked out at that water, and said yes again. When she passed away at 98, her daughter inherited the cabin and the lease. The daughter renewed it as well. That is now over 3.5 decades of genuine continuity in a single family's relationship to a piece of land they never owned but absolutely belonged to. The Idaho State Land Board never sold that land. The terms of the lease never changed dramatically. What changed was Margaret's understanding of what security actually means. She was not waiting for ownership. She was not saving for a down payment. She was simply renewing her right to be there, year after year, in a place where her life made sense. That is the secret I promised you at the beginning of this video. The state land loophole is not actually a loophole at all. It is not a trick. It is not a way to steal something from the government or dodge some rule. What it really is a bridge between 2 completely different visions of security. On one side stands the American dream as it has been sold to you. Own the land, own the house, own it all, or you own nothing. On the other side stands something quieter and actually much older. The understanding that what you truly need is stability, presence, and the right to be somewhere for as long as you need to be there. When you lease that cabin in Montana for 15 years at $40 a month, you are not settling for less. You are making a conscious choice about what security actually looks like to you. You are saying that a view that costs $3 million somewhere else is worth changing your life for, and that you would rather have 30 years of morning coffee beside that water than a property deed that you can flip for a profit. The states that offer these leases are not hiding them. They are advertised. They are open. The reason most people do not know about them is simply that they do not fit the narrative we have been told to want. A cabin on public trust land does not make a good real estate investment. It cannot be flipped. It cannot be collateralized easily. It cannot be leveraged into something bigger. For the bank and the developer and everyone who profits from the constant churn of property ownership, this arrangement is nearly invisible. But for anyone willing to ask a different question, not how do I own more land, but where do I actually want to belong, these cabins become the most honest real estate deal available in the entire country. Here is what I want you to do this week. Look up the State Lands Office website for any state where you have ever thought you might like to live. Spend 30 minutes reading about what they actually have available. Do not commit to anything. Do not even call anyone. Just look. See what is actually out there waiting for someone to say yes to it. Because once you see these cabins, once you understand that your state government is willing to let you live on that lake for less than a monthly phone bill, the entire conversation about where you belong shifts. The certainty you are looking for does not live in a deed. It lives in a lease you are willing to renew, in land the state will hold steady while you live your actual life on it, and in the simple act of saying yes to the view you already love instead of waiting for the one you think you are supposed to want. Thank you so much for watching all the way to the end. If this opens something up for you, if you are thinking differently about where you belong, please subscribe and hit that notification bell so you never miss when we find the next cabin, the next lease, the next place that is waiting for someone exactly like you to say yes. Leave a comment below and tell me which state called to you the most. I read every single one, and I cannot wait to hear which lake or forest or mountain view just became real in your mind. Thank you again, and I will see